So here you have Amy Coney Barrett saying that the taxpayer suit is a similar inadequate historical analogy because we're looking at the common law, right? So when King Henry VIII had beheaded two of his queens in order to have sex with his mistress, we're going to pay attention to the laws of King Henry VIII. And we're also going to make sure that the ordeal by cold water and boiling water, the ordeal by battle, the ordeal by candle and cross, and the ordeal by blood, we're going to make sure these ordeals are still in play. The ordeal by blood, if somebody is suspected of a murder, then the person who is suspected of a murder goes to the body, goes to the corpse and touches the corpse, and if the corpse moves or if it bleeds where the person touches, then that's the person's soul trying to get out for revenge. So if a person touches the body, which actually makes me think about Karen Reed when she pulled out that piece of glass out of John O'Keefe's nose and blood spurted out. So she would have lost the ordeal by blood. So that's, there's no logic to the thing. There's no logic to the thing. For me, I feel like you need evidence and witnesses. That's what determines whether somebody's guilty or not. If somebody, did the damn thing, well then evidence and witness statements get to, the truth. We need to find out the truth. Objective justice rests upon objective truth. In a successful taxpayer suit, so I think that she's wrong about this. In a taxpayer suit, if one person sues against a tax and then they are victorious, then you do the, massive injunction, the nationwide universal injunction. The tax doesn't apply to anybody at all. So that is a good analogy. We agree that the complete relief principle has deep roots in equity, but to the extent respondents argue that it justifies the award of relief to non-parties, they are mistaken. Consider the civil contempt context. Under traditional principles of equity practice, courts may impose civil contempt sanctions to coerce a defendant into compliance with an injunction. Taggart v. Lorenzen, 2019. So another big problem that I have with this Trump v. CASA decision 2025 is that they are just ignoring birthright citizenship, and they're saying the tool to stop birthright citizenship isn't the right tool. I think it's the perfect goddamn tool. It is the perfect motherfucking tool. Somebody takes away your right to bear arms, you just have a universal injunction to stop something like that. Somebody tries to take away your right to speak, your right to petition, your right to peacefully assemble, or the right to birthright citizenship. That's the Constitution. So there's a quote later on I'm going to read about how she says that Justice Jackson is getting away from the Constitution, but actually it's Amy Coney Barrett that's getting away from the Constitution. The Constitution, the 14th Amendment, says if you're born on this soil, then you're an American. Let's see, consider an archetypal case, a nuisance in which one neighbor sues another for blasting loud music at all hours of the night. To afford the plaintiff complete relief, the court has only one feasible option: order the defendant to turn her music down, or better yet, off. That order will necessarily benefit the defendant's surrounding neighbors too. There is no way to peel off just the portion of the nuisance that harmed the plaintiff. But then later on, she's going to say that if the nuisance persists, then another neighbor wants to shut it down, she must file her own suit. What the fuck? So if one person sues another person for playing loud music, and the court didn't resolve that, and the loud music continues to be played, and somebody else is bothered by it, then that other person is supposed to file suit? The other person is supposed to file suit in order to shut down the music. The courts didn't fucking solve the problem to begin with. So why would the second person even fucking file a goddamn suit to shut down music when the courts are totally impotent and inept and without, totally devoid of any power to stop the wrongdoing? The individual and associational respondents are therefore wrong to characterize the universal injunction as simply an application of the complete relief principle. Injunctive relief should be no more burdensome to the defendant than necessary to provide complete relief to the plaintiffs. Let's see here. They argue that a universal injunction is sometimes the only practical way to quickly protect groups from unlawful government action, and they suggest that forcing plaintiffs to proceed on an individual basis can result in confusion or piecemeal litigation that imposes unnecessary cost on courts and others. Let's see here. I'm going to keep on reading. There was a bunch of concurrences too. So you had the majority opinion, but then you had 3 concurrences and 2 dissents. So this document is 119 pages. You know, this is prolix and verbose. This Trump v. CASA, Trump v. CASA, I think that's going to be the biggest impetuous I see to stop. It's hard to pronounce. Was it CASA or CASA? Universal injunctions incentivize forum shopping since the successful challenge in one jurisdiction entails relief nationwide. Nothing like a universal injunction was available at the founding, or for that matter, for more than a century thereafter. Thus, under the Judiciary Act, federal courts lack authority to issue them. The Bill of Rights wasn't applied to the state until 1925, and then it wasn't until the 60s that they started incorporating more of the Bill of Rights to the states. So using her logic of precedent, well, our Bill of Rights is just, you know, a bunch of paper that doesn't mean jack shit. I would like to think there's one thing that all Americans can agree on, since we're a free nation, we're a free people living in a free nation. Therefore, our Bill of Rights, just the 10 rights in our Constitution, is the law of the land. And a universal injunction is perfect. That's a perfect way. Somebody tries to say, okay, you don't have the Second Amendment. You know, let's say a president gets in there and they come after your guns. Well, then a universal injunction would make sense. Our observation in Grupo Mexicano rings true here. Even when sitting as a court of equity, we have no authority to craft a nuclear weapon of the law. There is something where she had said she's criticizing Justice Jackson, and she's trying to say that just because you're against an imperial executive doesn't mean that you should be allowed to have an imperial judiciary. If the executive is going to be imperial, then that would imply that both the legislative and judicial branches, they better be imperial to catch up with the fucking executive. The whole point of checks and balances is that you have 3 co-equal and co-independent branches of government. And she warns if courts lack the power to require the executive to adhere to law universally, courts will leave a gash in the basic tenets of our founding charter that could turn out to be a mortal wound. It absolutely could. In her law-declaring vision of the judicial function, a district court's opinion is not just persuasive, but has the legal force of a judgment. If a district court judges a case and they comes down with a judgment, Coney Barrett is saying, nope, they don't have the power to judge. Judges in district courts don't have the power to judge. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. No, you're wrong. The Constitution protects birthright citizenship, you goddamned asshole. We will not dwell on Justice Jackson's argument, which is odds with 2 centuries worth of precedent. The Bill of Rights is at odds with a bunch of precedent. 1925, so what is that? That's 150 years. 150 years we did not enforce the First Amendment, the freedom to speak or the right to press. So according to precedent, that means the Bill of Rights isn't a part of the damn thing, but the judiciary does not have unbridled authority to enforce this obligation. In fact, sometimes the law prohibits the judiciary from doing so. See Marbury v. Madison, 1803, concluding that James Madison had violated the law, but holding that the court lacked jurisdiction to issue a writ of mandamus, ordering him to follow it. That is not the only... God, Marbury v. Madison contains a bunch of stuff. Marbury v. Madison, the main thing with Marbury v. Madison, you learn in college, you learn in just basic high school social studies, is that it established judicial review, meaning that the judicial branch can review the executive and legislative branches to see if the damn thing is constitutional or not. So there is a lot of specifics to the thing with James Madison and the mandamus. James Madison was the Secretary of State, I want to say. So John Adams appoints all these midnight judges, and then Thomas Jefferson refused to seat the judges, and then it goes to the Supreme Court. And in Marbury v. Madison, they said that Madison had violated the law, but holding that the court lacked jurisdiction to issue a writ of mandamus ordering him to follow it. So basically, he split the baby. He split the damn decision. It was a split decision. But Marbury v. Madison was establishing judicial review. So they're saying, of course we have a right to see if something is constitutional or not. If you have a statutory law versus the constitutional law, the Constitution reigns supreme. The Constitution defeats the statute. So there's a lot more to it. There's also, we're a nation of laws, not of men. There's also, you have the federal government can check the state government. There's a lot to Marbury v. Madison. So the end conclusion was that Marbury didn't get to get his damn seat, because Jefferson was the new president and he refused to enforce the midnight judges of John Adams. So, I mean, let's see, it's required by a judge's oath to follow the law. Justice Jackson quotes Marbury v. Madison extensively. If a judge in the District of Alaska holds that a criminal statute is unconstitutional, can the U.S. prosecute a defendant under the statute in the District of Maryland? Perhaps Justice Jackson would instinctively say yes. It is hard to imagine anyone saying no. No. If the goddamn judge in the District of Alaska says that a criminal statute is unconstitutional, then it needs to go to the Supreme Court to determine if it's constitutional or not. Because you're saying that the district court doesn't have the holding power of judgment. So if the District of Alaska says that a statute is unconstitutional, you're saying you could just go to Maryland and then get the fucking enforcement that you want? Talk about judicial. There's so many contradictions in this. This is shopping. This is forum shopping, judge shopping. But why, on Justice Jackson's logic, does it not violate the rule of law for the executive to initiate a prosecution elsewhere? It does violate the rule of law. If it's unconstitutional in Alaska, then it would be unconstitutional in Maryland and Montana. Finally, the government must show a likelihood that it will suffer irreparable harm absent a stay. Nicken. When a federal court enters a universal injunction against the government, it improperly intrudes on a coordinate branch of the government and prevents the government from enforcing its policies against all this bullshit is kind of saying that they're going to rule against birthright citizenship. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power too. I don't think you understand checks and balances. If the executive breaks the Constitution, then the legislative or the judicial branch needs to rein the executive in, or then it's up to us, we the people, to do so. The Constitution isn't just maybe it's an old-ass piece of parchment that has no staying power whatsoever. Maybe the Supreme Court justices are just wiping their asses with the Constitution. Then Justice Thomas with Justice Gorsuch is going to join in a concurrence, and I'm only going to talk a little bit about them. I read Sotomayor and Justice Jackson's dissent in full, and then I read Barrett's majority opinion in full. But these concurrences, it's fucking too long. This is prolix and verbose. That conclusion is dispositive, as I previously explained. So they're trying to, let's define dispositive. Dispositive means that the disposition of the case has been solved. If district courts have any authority to issue universal injunctions, it must come from some specific statutory or constitutional grant. Courts must not distort the rule that injunctive relief should be no more burdensome to the defendant than necessary to provide complete relief for the plaintiffs. So they're protecting the defendants. Kavanaugh v. Yamasaki, 1979. Otherwise, they risk replicating the problems of universal injunctions under the guise of granting complete relief. In no circumstance can a court award relief beyond that necessary to redress the plaintiff's injuries. Complete relief is not a guarantee. It is the maximum that a court can provide. I got this one book that says, making it up as they go along. And while the Supreme Court justices and a lot of people that's in law, they say basically they look to the law, and the law determined the outcome of the case. It wasn't that they had predetermined it or that they had judged it on its own, its merits secretly in their own minds. Because a lot of times when the Supreme Court writes an opinion, they'll just say, well, according to the Constitution, according to the precedents, and according to, the Federalist Papers, and according to this thing and the other. I'm not actually making a decision here. The law made the decision for me. I'm just following the law. The law made the decision for me. It's like when they try to throw that one guy in jail. He had a truck accident and a couple people died, and then they gave him a 110-year sentence, a life sentence essentially, for an accident. And then the governor went ahead and pardoned it. But the reason why they did that was the judge in those cases was saying, well, I got to obey the law. And the law says 20 years for each life that was lost. And since there was, 5 or 6 lives, and then they ran it concurrently. Or consecutively. They could have ran it concurrently. So there's a lot of problems with judges, people pretending that judges are just enforcing what the laws say that should happen. I mean, a judge could just go against somebody because they disrespected or perceived disrespect. They're making it up as they go along. And since they're making it up as they're going along, they're veering wildly out of orbit. They're going to knock Earth off its axis. Throw us out of orbit. So here's another, Justice Alito, with whom Justice Thomas joins, the availability of third-party standing and class certification. So Alito is going to say, okay, they might not come, after birthright citizenship with these universal injunctions now, since we just slammed it. But maybe they'll go some other way. Maybe they'll go through class certification, through Rule 23. And then what about the availability of third-party standing? We haven't ruled on third-party standing yet, This case is, people are suing on behalf of other people. So mothers who have children born in America, this is, organizations who have brought this case up. And so they're trying to say that, well, they're actually representing third parties. They're not even representing themselves. The court does not address the weighty issue whether the state plaintiffs have third-party standing to assert the citizenship clause claims of their individual residents. I mean, the fucking goddamn mental gymnastics that they are going through in order to kill birthright citizenship. They're coming for our Constitution. The Constitution says you're born in America, you're an American. You got 8 U.S. Code 1401. A person born in the U.S. is subject to this jurisdiction. These are people who are nationals and citizens of the United States at birth. A person who is born in the U.S. to a member of an Indian, Eskimo, Aleutian, or other aboriginal tribe, provided that the granting of citizenship under this subsection shall not in any manner impair or otherwise affect the right of such person to tribal or other property. A person born outside of the U.S. and its outlying possessions of parents, both of whom are citizens of the U.S. and one of whom who has had a residence in the U.S. or one of its outlying possessions prior to the birth of such person. A person born outside the U.S. and its outlying possessions of parents, one of whom is a citizen of the U.S., who has been physically present in the U.S. or one of its outlying possessions for a continuous period of 1 year prior to the birth of such person, and the other of whom is a national but not a citizen of the United States. A person who born in an outlying possession of the U.S. of parents, one of whom is a citizen of the U.S. who has been physically present in the U.S. or one of its outlying possessions for a continuous period of 1 year at any time prior to the birth of such person. A person of unknown parentage found in the U.S. while under the age of 5 years until shown prior to his attaining the age of 21 years not to have been born in the United States. So right there, I mean, if you are found in the United States and you are under the age of 5 and there is no evidence to say that you were born in any other country, then you're an American citizen, which that totally makes sense. You're a little, 4-year-old running around America. Maybe you were born in Guatemala. Maybe you were born in goddamn Texas. You don't fucking know. You're fucking 4 years old. A person born outside the geographical limits of the U.S. and its outlying possessions of parents, one of whom is an alien. Okay, so it gets to more specifics there. So, Ted Cruz, his mother was an American, but she had Ted Cruz in Canada, and then his father was Cuban. So Ted Cruz has a very thin understanding he's got a very thin citizenship. He's got a very thin pathway to citizenship. Is Ted Cruz even a citizen of America? I don't know. Ordinarily, a litigant must assert his or her own legal rights and interests and cannot rest a claim to relief on the legal rights or interests of third parties. Powers v. Ohio, 1991. Admittedly, the court has not pinned down the precise circumstances in which third-party standing is permissible, and commentators have emphasized the need for greater doctrinal coherence. No, do they? Bringing an end to the practice of runaway universal injunctions, but it leaves other questions unanswered. Second, today's decision will have very little value if district courts award relief to broadly defined classes without following Rule 23's procedural protections for class certification. The class action is a powerful tool, and we have accordingly held that class certification is proper only if the trial court is satisfied, after a rigorous analysis, that the prerequisites of Rule 23A have been satisfied. Walmart v. Dukes, 2011. We should have class action lawsuits because that's the loophole. The loophole is to have a class certification of American citizens, have a We the People Foundation. The American citizens is a class, and we think that the Constitution says what it means and means what it says. According to John, the first clause of the book of John, he says that God is the Word, and the Word is God. So when the Constitution says, if you're born on the soil of America, then that makes you an American, well, that is God. The Constitution and the Bill of Rights, the preamble, all the Constitution is God. The Constitution thumps statutory interpretation. Lax enforcement of the requirements for third-party standing and class certification would create a potentially significant loophole to today's decision. So that's what Alito is, worried about. Well, we maybe we've stopped this fucking lawsuit, but you haven't stopped him from taking away our goddamn Constitution. So Justice Jackson, she's crying, she's kind of being a Chicken Little crying for the hills, but in a way, everything that she's saying is totally right. You're going to fucking ruin the republic. You're going to ruin the constitutional republic. Here's Justice Kavanaugh. He's concurring too. So, okay, do any of these men respect a woman's, decision? So, Coney, Barrett wrote the majority opinion, but both, or all three, Kavanaugh and Alito and Thomas and, I don't know, they concurred, they joined in the concurrence. But there is, three of these conservative men are saying, well, let's add a little addendum to what she wrote, okay? The plaintiffs here sought preliminary injunctions against enforcement of the president's executive order on birthright citizenship. And also, why do you have to have 4 or 5 or 6, 17 goddamn different opinions? If the Supreme Court, if the decision or the ruling of the Supreme Court is going to hold, then it should be, basically used with one voice. That makes a lot of sense. We're going to use one voice and we're going to make this decision, unless there's just some big gaping hole. If there's a big gaping hole, put it into the majority opinion. The plaintiffs here sought preliminary injunctions against enforcement of the president's executive order on birthright citizenship. The district courts granted universal preliminary injunctions, that is, injunctions prohibiting enforcement of the executive order against anyone. Anybody who's born in America, which makes you an American citizen, can be deported to a concentration camp in Sudan any point in time. So ICE typically has been going after, brown folks, so white supremacists might feel like this isn't going to apply to them, but if they're going to, get arrested and say that they're an illegal, they'll have to prove that they were born here and plus other documents to say that they're citizens. They're going to have to prove more than just being born here. And that should be enough. Proving that you were born here. Most significantly, district courts can no longer award preliminary, nationwide, or class-wide relief except when such relief is legally authorized. He's talking about the interim before the interim. So Kavanaugh's like, hey, I want to talk about the interim before the interim. Courts of appeals in this court can and regularly do expeditiously review district court decisions awarding or denying preliminary injunctive relief. In justiciable cases, this court, not the district courts or courts of appeals, will often still be the ultimate decision maker as to the interim legal status of major new federal statutes and executive actions. That is, the interim legal status for the several year period before a final decision on the merits. What? What the fuck? What are you talking about? He's saying that this could take years. The president wants to take away our Second Amendment, First Amendment, Third Amendment, Fourth Amendment rights. They want to take away habeas corpus. They want to take away birthright citizenship. Well, we'll go ahead and squabble over the tiny little things, but then ultimately, when it comes to the big decision, was his fucking executive order. He's issued like 500 executive orders so far. So, because you have all these fucking laws, it does make sense to everybody be on the same page, but this is just rule by decree, rule by fiat. This is just one fucking guy saying, hey, fuck the Constitution and fuck your rights, and I'm going to deport whoever the hell I feel like deporting. He's even suggested, deporting American citizens. He's suggested it several fucking times. So he's saying that this might take several years. Well, that's not a very good fucking... What a weak, inept, impotent. Kavanaugh, you're impotent when it comes to stopping birthright citizenship. He's breaking the Constitution, and then you're going to allow him to fucking do it. You're going to allow him to fucking do it. That's what all these words say to me. If somebody kicks somebody in the fucking dick, and then they take it to court to sue the person, well, they're going to try to, on the technicality or some sort... This is like what Jesus says. You strain out a gnat, but you swallow a camel. You sit there and make a big importance when it comes to tithing mint and cumin and dill, but you forget about the bigger virtues of mercy and faith and justice. You forget about justice. And then there's a couple other biblical passages when it comes to what Jesus says about lawyers. So let's take a look at the book of Luke, chapter 11, and then I got it marked down here, 42. So there's probably two things. It isn't just chapter 11, but you also have the book of Luke, 46. I want to say 11:46. So let's take a look at Luke 11:46 says this. And he says, woe to you also, lawyers. Woe to you, lawyers, for you load men with burdens hard to bear, and you yourselves do not touch the burdens with one of your fingers. You do not help ease the burden with one finger. You sit there and pile a burden on somebody's back, and you won't even lift one finger to help ease that burden up. Then there's 11:42. Woe to you, Pharisees. Oh, you tithe mint and ruin all manner of herbs. There's another one here. 52, yeah. Woe to you, lawyers. This is Jesus Christ speaking. Woe to you, lawyers, for you have taken away the key of knowledge. You did not enter in yourselves, and those who were entering in you hindered. I'm not sure what he's talking about, entering the temple or something, or the kingdom of heaven. You didn't enter the kingdom of heaven. You didn't jump into the goodness, the righteousness of goodness. You take away the key of knowledge. And then you load men with burdens hard to bear, and you yourselves do not touch the burdens with one finger. And then there's Matthew 23:13. What is this passage about? I wrote it down, so let's read it. Aren't we all interested in what Matthew 23:13? Matthew is just so revolutionary, it's not even funny. And then I also like the passages about stay prepared. Because when the end times happen, mankind, humankind, it's cyclical. Civilizations and empires, they come and go. The Roman Empire, they lasted for 1,000 years or so. The Chinese Empire, the Mongolian Empire. You've had all these empires, the Ottoman Empire, the Austrian, Hungary Empire. You have all these empires, and then they just crash and burn. You have all these empires, and then ultimately they just crash and burn. So to think that, and then also, let's think about 9/11. We were all talking about Gary Conduit and Chandra Levy. So there was a senator, there was an intern who had died, and that's interesting. Maybe we should go back to that. But that conversation quickly got buried in the 24-hour news cycle because of 9/11. Then nobody was talking about it. So what I'm pointing out with that is that, all the damn issues that you're talking about now, the moment North Korea bombs the crap out of us, or hell, maybe Canada does it. Maybe goddamn England will come back and burn our White House. They've done it once before. So the moment that we get into a war with England, and then people are just starving on the streets and barely able to survive, all these stupid conversations that we were having before that happened, you should be prepared. He had the parable of the 10 virgins. And the 10 virgins, there was a wedding. And then there was people that stayed outside. Some of them had oil and they lit their fires so that way they could, see throughout the night and wait for the groom. And then before the groom comes, some of them didn't have oil, and so they went to the nearby town to get oil for their little lamps. And by the time they came back, the groom had already showed up, and the people who were prepared got to go to the wedding. So that reminds me of luck is when preparation meets opportunity. Luck is when preparation meets opportunity. So Matthew 23:13 says this, "But woe to you, scribes and Pharisees, hypocrites, for you shut up the kingdom of heaven against men, for you neither go in yourselves, nor do you allow those who are entering to go in." Yeah, that's what he's talking about, the kingdom of heaven. You take away the key of knowledge. You take away the opportunity for other people to enter into the kingdom of heaven. A lot of things, Jesus is so fucking great. A lot of what Jesus says, you can take away all the magic tricks. You can take away all of him, being the Son of God. Specifically, he isn't the only Son of God. What if every human being on earth is the Son of Man and Son of God? Man was made in the image of God. And so Jesus is just saying, since we are all men, we're all women, we're all people, we're all humans, therefore we're all gods. And you should respect each and every one of us as if we are the gods that we are. We are so much more capable, so much more powerful than, what anybody would give us credit for being. It's our light, not our darkness, that people are afraid of. So, you have several of these decisions, and they're sitting there, saying blah, 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 dee, blah, 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 blah. I feel like they're going to revisit. This case is going to be, I don't think this is going to hold very good. It might hold against, universal injunctions, but if somebody gets class certification through Rule 23, the taxpayer thing, if somebody gets a tax, is ruled illegal. So Kavanaugh and Alito and Thomas and Gorsuch, you got 4 Supreme Court justices that's like, okay, Amy Coney Barrett said what she said, but 4 of the 5 men, so not Justice Roberts, he's the only one that didn't correct her. So she issued her opinion, but then they said, well, let's correct what you said. You didn't say it exactly the way I would say it. And so they had these concurrent opinions. So interesting. Really, the majority isn't even agreed upon what they're trying to say here. They just want, Donald to fucking win, and they're changing all the rules. They're against the civil rights, the civil acts, the Civil War amendments. They're against the 13th, 14th, and 15th Amendments.